Hey. That sense of direction, zippo.
Okay, I think we began.
Have we started?
Hi, yes.
Hi, everyone. Thank you for joining us. Good afternoon. My name is Alinda, and I'm a lawyer here at Barefoot Law. We're going to have a fun conversation today talking about employment, labor issues, and all things to do with work. So, as you come in, feel free to ask questions in the comment section. We're going to be looking at them. We already have some questions that came in, so we'll start with those. But if you have anything that you've always wanted to know about work, about employment, about labor, and how different labor matters are treated in Uganda, today is your opportunity to learn. So sit down, enjoy. I am with
Alan Moya, a lawyer with Barefoot Law, and I think you can see me now, right?
Yes.
Yeah. So Alan Moya, a lawyer with Barefoot Law, working with the content department as well, and I'm happy to be here.
Okay. So you're welcome. We see all of you guys joining. Thank you so much for joining. We're going to start off easy, and then as we progress, we're going to have the more difficult questions coming in on different employment issues. I don't know if you can see me, but let us know how the sound is, how the video is. Let us know if you can hear us, if you can see us. Let us know, and we'll be able to, deliver the best TikTok live that we can. We're going to start off with the question on what is employment in the first place. What is work? Even before we get into employment, generally speaking, what is work? We've had a lot of, usually when people graduate from school, immediately they're like, hey, I can't wait to hustle, I can't wait to work, all these things. So we want to set a clear distinction. I think that's the first question I'm going to ask Glenn. We want to set a clear distinction between work, general work, and employment. If I go after school and I start my business down in Chikugo, I start selling phones. Am I employed under the Employment Act? Does that mean I'm employed? Or if I have an online business, I finish school and I start designing and I put my things online, is that employment? We've also had the term self-employed. I'm self-employed. Does that mean I am covered under the Employment Act? So tell us exactly what is the difference between work and employment as we start to define what we're talking about today.
Okay, that's a bit tricky. We've thought about it a lot, but we've never really put our minds to what it really means, self-employment. But generally, employment comes down to being you giving your time to someone in exchange for a certain amount of pay. Now, that amount of pay is what we usually call remuneration as lawyers.
Yeah.
It could be a salary, it could be a wage. A salary is what you get at the end of a month.
Yeah.
A wage is you get, if they say you get paid every day, that's a wage. You get paid every week, that's a wage. But what you get at the end of the month, because of the time you're selling somebody else, is a salary. So when we say you're employed, we mean there is somebody who you have given your time to for a certain pay at the end of the month. Self-employed.
Now us who do our own thing, where are you putting us? Government
Yeah. Now that's where it kind of gets tricky. Okay, let's give it a name.
Yeah.
Shivan Incorporated. If Shivan works for Shivan Incorporated, that means Shivan is employed by Shivan Incorporated.
Yeah.
So that means even if she says she's self-employed under that company should be able to be able to pay her a certain amount of money And because of that, even the law will be like, maybe Shivan should be paid. I should pay NSSF and they should contribute to her NSSF. She's getting that as an employee. If there is no company, you just know you're your own hustle, I don't think you're employed. You work, but you're not employed.
Okay.
Yeah.
So we've clearly stated that the distinction between work and employment is that for an employee, for someone to be called an employee, there has to be a formal recognition that you are an employee. It can't just be words of you saying, oh, I work, what? It has to be formal. And I think the Act makes it very clear. Whenever we mention the Act, generally speaking, we'll be talking about the Employment Act of Uganda. Now, the Act clearly states that for you to be an employee, you have to have what is called a contract of service. A contract of service is what makes you an employee in Uganda. A contract of service is different from a contract for services. Now, we are using two words here. There is of and for. A contract of service means Alan found me somewhere and he said, I have a certain skill set that he wants. So he offered me the opportunity to work with or for him, and I agreed. So we put all that down in writing, and he said, I am employing you to do such and such a task between such and such a time, and I'll be paying you such and such an amount of money. That is a contract of service. It must be clearly stated. Now, the Act also says it can be either written or oral, meaning for you, your employer might have just called you and you spoke over phone and they said, oh, this is the contract word, but we must reconcile that and remember that the Contracts Act says that every contract above 500,000 shillings must be written down. So if you have a boss who has been working, who has employed you to work for them, and they are paying you more than 500K, but you don't have a written contract, you're in trouble, because it will be very hard for you to fight for your rights in the event that there is a dispute between you and your boss. So it's very important, if any of you is listening to us, please make sure you have a contract of service in order for you to be considered an employee. Usually it's called an employment contract. Usually that's what you'll see on it, or contract of employment. You'll see that on it. You'll sign it. It usually defines your benefits as an employee. It defines termination, what happens when you do something, so many things. So that's the general basic definition of employment. Alan, we have this category of people. They work, they are paid, they even receive benefits, let's say. But they are paid maybe like every day. Let's say like downtown. Every day he knows he has an assured job. They've never chased him. If he falls sick, even his boss will pay for his treatment. But he's just downtown. Maybe he moves things for his boss, things like that. Those ones, what do we call them? Because we've said they're not employees. What do we call them?
Okay. Now, the thing is this, that you've termed it very, very well, actually. They work, they know they have an assured job. Like, in Uganda, actually, the word is mpakasa.
Yeah. Yes. You
usually see them, especially when they say, the truck will come, so you will come and unload. Or we have a building site, come. You'll be a porter, whatever, stuff like that. Now, these kinds of people are not usually termed as employees, but are called casual workers, because, I mean, you are casually doing this work. You show up here, do the work. Tomorrow you go to some other guy's site, or you go and unload for somebody else.
So there's no loyalty.
Yes.
Okay.
What usually sets what we would call contractors, casual workers, apart from employees, is that, like we said in the beginning, it's my time, my skill set and my time that you're taking, which means 8 to 5, I owe you that time.
Yeah.
Now, this guy is only here to do this work today, tomorrow. On 3 other days, he may even not show up. He's not bound to show up and do your work.
Yeah.
However, if you make this guy do this work 1 month, 2 months, 6 months, at that point, the loyalty has kicked in. I mean, I've been here 6 months. I have an expectation that you're going to be giving me work going forward. And you also expect that I'm supposed to be here every day for 6 months. I've already been here. At that point, I become an employee because I've been loyal.
Hey, so if I'm loyal to someone for more than 3 months, I think that's what the act says. If I'm loyal to you for more than 3 months, it means you have to make me your employee.
Well, if I'm here every day.
Yes.
Every day. Yes.
Okay.
Not loyal because for yourself, me in my heart, I know I win the work. No.
I'm like, showing up.
I'm showing up. You're giving me work every day.
Yeah.
That simply means I'm now an employee. I'm no longer casual.
Okay. So if you're just joining us, we're having a conversation on employment, what it looks like, what it means, the terms and conditions that follow employment. And Alan has just dropped a bombshell. He's told us that if you work for someone consistently for a period of 3 months plus, and you consistently turn up to work, and you've not yet been given a contract of employment, but you show up, you're a loyal worker, then the law automatically views you as an employee. What that means is your employer is mandated to give you a contract of service for you to become permanent staff because you've shown loyalty, but they have also extended you a period of time within which to offer your skill set. So we've said there's a distinction between employees and casual workers. We've said employees have an actual contract that states these different things that they're supposed to do, when they should be at work, when they should leave, their benefits, etc. And we've said casual workers just come every day, like as we've had it, it's casual.
Everyday food.
So really, it's in the term is in the answer is in the term. Interns are not employees; they are interns. The law actually also provides for that and calls them apprentices. Basically, what an apprenticeship contract is that you have come to learn from me, the one who is an expert. You're not working for me. You're not my employee. You're learning from me. I'm teaching you.
I'm giving you skills.
Yes, I'm giving you skills. So that's what usually internship contracts look like. They are contracts for apprenticeship where the person who is the intern is an apprentice. Essentially, they are learning from whoever has given them the opportunity to learn. So interns are not employees, and neither do they have the benefits that are accrued to employees. But we've ever talked about this thing, benefits. If you give me a contract like this and say, today I want you to be my employee, what benefits should I expect? Or why should I be an employee and not a casual worker? Because the other side, if I'm a casual worker, I can cover so many gigs. I can go here today, go here tomorrow. So what is the benefit of being an employee?
We're going back to the word loyalty, right?
Yes.
Because I am loyal to you, I expect some things from you. And the things you expect are the benefits. That's the most basic definition of a benefit. The things I expect from you because I am loyally giving you my time, my skill, my labor. Why should you work for only myself? One, I guarantee you that every month I'm going to give you two days something as a holiday. So when you accumulate those days, you call it annual leave. I guarantee that even if you're a lady, you get pregnant, you give birth, even if you go give birth, I'm going to give you 60 working days. Go look after yourself, look after the baby, come back, your place is guaranteed. You're going to find your job waiting for you now. If you work here and here and here and here, it's not guaranteed. The moment they hear her, she has gone, find a replacement.
That's it. You
see?
Yeah.
I also guarantee that at the end of the month, at the end of every month, you're going to be paid.
Yeah.
If you're a casual worker, when we're out of money, you better go hunt somewhere else. And if there are no gigs elsewhere, you might starve. So these are the benefits, things like that. Apart from this, there are the other benefits that are dependent on who you're working for. Medical insurance.
Yeah.
Medical insurance comes in because you say, For me, I am able to look after you if you do fall sick. I'm able to look after your kids. I'm able to look after your husband, your wife.
Yeah.
Those medical benefits, those are optional.
Yeah.
However, if you do, the one that's not optional is if you do get injured while working for me, while leaving work, while coming to work, well, because you're loyal to me, there is an expectation that I'm supposed to compensate you. I'm supposed to look after your health, to pay you for the injury, to continue paying you salary even when you're sick, which takes us to sick leave. If you do fall sick, I am supposed to continue paying you for at least 2 months. After 2 months, of course, I could look for somebody else and tell you no longer work for me, but at least for the first 2 months that you're sick, there's an expectation that you will continue getting salary. Second month will be half, but you'll continue getting your salary. So these are what we call benefits, and why you can only get them from one person and not if you work everywhere for everybody else. Yeah.
Okay. Thank you, Alan. So we've mentioned if you are an employee, some of the key things you should look out for in your contract to make sure you're not being cheated out of your benefits. Make sure that contract clearly states your wage, your salary or remuneration. How much are you being paid per month? Make sure your contract clearly states your leave days, annual leave. How many days are you given off in a year? That's an entitlement under the law. We also are saying that make sure your contract clearly states whether or not you are allowed to take leave when you're sick and whether or not you'll be paid for that sick leave. I think that the Act actually calls it sick pay, that when you're not at work, you'll still be paid for the days that you're off, but that only applies for a specific period of time. So you cover sick pay. The Act also says you are entitled to maternity leave. If you're a mom out there and you're employed and you have a baby, please make sure you check your contract and make sure that it has a provision for maternity leave.
What if you're a dad?
Exactly. I was actually going to come into that. If you are a dad watching us and your baby that is going to give you a baby just had that baby, make sure your contract also provides for paternity leave. Paternity leave is an entitlement under the Employment Act, and essentially what that means is that as the father of the child, you are granted days off, paid days off for you to go and look after your child and the mother as they recuperate from the birthing experience. So that's paternity and maternity leave. We also have to talk about something interesting. Work hours.
Before we get to the work hours,
Yes.
one benefit we actually left out that's really, really important. A casual worker will show up this morning and boss ajja gamba, leero tewali sente ojja kujja oba tokomawo. As an employee, they can't chase you like a rat or a thief.
Yeah.
Your boss is supposed to give you, if you've worked at least for 6 months, 2 weeks notice. Notice being, he's supposed to make you aware that in 2 weeks' time, I won't be able to provide work. Go home, don't come back. If you've worked for at least a year to about 3 years, he's supposed to give you a whole month's notice, like to make you aware a month before time that, next month I won't be able to pay you or I won't be able to give you work. So whatever we're doing, this thing is done. Obviously, if it's longer than that, if it's 3 years to 10 years, they're supposed to give you 2 months notice. More than 10 years, 3 months notice.
Okay.
That's what sets you apart. That particular benefit is very important. You are assured that you have work a month ahead of time.
So they can't just wake up and chase me.
Yeah, they can't just fire you like that. If they do that, either they're supposed to pay you for that whole period, they should have made you aware, or you can actually sue them.
Okay.
Yeah.
Okay, that's a very important one to note. But now, what about us who also I was there during the course of employment and another offer came and I no longer want to work for you. Do I also have to tell you that I'm leaving or I just pack my belongings? Already, I didn't want to be
I didn't want to be there.
I just pack my belongings and I
The
leave.
situation has come to an end.
Do I also have to give notice to my employer when I'm leaving?
Well, it's good manners not to sneak out.
Yeah.
But the law doesn't demand for it.
Okay.
Because the way laws work is you are supposed to protect the weaker party.
Mm.
In any relationship, there is always someone who suffers more than the other, one who tends to have more power than the other. Like if you've been, let's not go there. Okay, so seriously, because your employer has literally hiring and firing power over you to pay you, to change terms and stuff like that, and you're the one who humbly applied for that job, the thing is, the law will make sure that they provide some protections for you, like we've just said. They can't just fire you just like that. They can't chase you away. Because you're the weaker party, there's no obligation on your part to particularly say, oh, I am leaving. But think about how it would reflect on where you're going. They tell you, when are you ready to work? Tomorrow. Have you been working somewhere else? Yeah. When are you ready to leave? Tomorrow. You just give me the contract, I go. So obviously they won't be like, this one has some bad manners. So it's just common courtesy that you're supposed to prepare, because you also found things prepared for you.
And I think, Alan, I've actually remembered another reason why you must tell your employer when you are leaving, just in order for them to prepare for your departure. Because another benefit of being an employee is at the end of your employment, you're entitled to a little beautiful thing called a certificate of service. A certificate of service is basically a certificate showing that you were a good person when you are working, you did well, you didn't disturb, generally good things being said about you. Now, if you just pack your belongings and sneakily walk away from your employer, never to be seen again, your new employer usually requires that certificate of service from your previous employer. How will you ask HR for that certificate of service if you run away from your previous job? So it's important that you give them notice, so that even in that notice, they prepare your certificate of service and they're able to give it to you to apply for your next job. And there's another thing I'd like us to talk about. We had mentioned we wanted to talk about work hours. I think the biggest issue we've seen even online with people complaining is work hours for employees. People will say things like, I think that's why even people started hating Mondays, because you're supposed to be at office maybe at 7, and then every day you also leave at 7, so you're working 7 to 7, you're working Monday to maybe Saturday. What does the law? Does the law even protect us, or whatever your employer says in the contract is what you should do? Can he tell me you're supposed to be here from 7 to 7 and I refuse? I'm like, no, me, I know my rights.
Eventually, I know we're going to talk about a small something called disputes. We will talk more about this part where you disagree with your employer about certain things. But a protected thing about employees is the fact that, well, you're not a workhorse. You're not supposed to work 24 hours a day. Like, always available does not mean 24-hour availability, 24/7. What it does mean, however, is you can work 8 hours a day, which comes to about 40 hours at the end of a work week. If your employer really pushes, because of their nature of work, they really need you to work, they're supposed to go and only push to 54 hours. 54 hours means those people who work Monday to Saturday. Now, if you count your 8 hours, usually, that's why everybody says 8 to 5. My math isn't the best, so I can't. I can't. 8, 9, 10, 11, 12, 1. Of course, in those work hours that you get, what we call 8 to 5, there should be 1 hour's break for you, to refresh, because even a car needs fuel.
So if my boss refuses me from taking that 1 hour's break, there's a problem.
There's actually a problem because the law demands it. What we keep getting back to this thing of what makes employment such a protected thing is the fact that there are things your boss would like, and there are the things that the law says your boss should give you. What your boss wants to do should not be less than what the law demands. The law demands that you get that 1 hour. The law demands that you work 40 hours. Or
so my boss can't say 30 minutes.
No.
So if you're watching this and for you they told you your lunch break is 30 minutes. After 30 minutes, swallow your food, like those high school things. swallow your food in 15 minutes and get back to work. There's a problem, and we're going to tell you how to deal with that problem in the consequent conversation. But Alan, you were still saying,
So you get the 1 hour, not 30 minutes.
yeah,
Eat your food, swallow, chew properly. I'm told there's a number of times you're supposed to chew, so make sure you eat your food properly.
Yes.
Don't get health complications.
yeah,
There are places that say our people shouldn't see food, so you're supposed to eat from under the table. No, eat your food well. 1 hour, rest in that 1 hour, go home. So 8 hours for work, 8 hours for you to relax, 8 hours to sleep. That's 24 hours in a day. Nobody said the time should extend more than that. If your employer says you should work more than 8 hours, there's something called overtime.
yeah.
So they're supposed to pay you a bit more to make you work over the time you should have been working. Yeah.
Okay.
There's that.
Okay. Thank you, Alan. That makes so much sense and also gives us so much peace, because where the internet is out here telling us how places can be funny, bosses are demanding overtime and there's no pay. So you're telling us that if I work over the time that we've agreed to work, I must be compensated monetarily for that time.
Yes.
Okay. Thank you. Now, there's something you mentioned which I'd want us to touch first before we get into the disputes. You said that one of the entitlements to employment is that if someone gets an injury when they are working, their bosses aren't supposed to pay for it. Tell me how exactly that works.
Well, I am loyal to you. I work for you. During the time I am working for you, it's like when you send kids to school.
Yeah.
Let's digress a bit. You send kids to school. Are you supposed to make sure those kids are safe at school when you're at work?
No.
No. So while I'm working for you, the time I have set aside to work for you, it's your job to make sure I am safe.
Yeah.
So I work 8 to 5, but you tell me, make sure that by 5 a.m. you're on the road. So whatever happens from the moment I step out of the house and I
start heading towards
to
my work. Yeah. That's
you're
on
responsible for keeping me safe. That's on you. From the time I leave office and I'm heading straight home, not to the bar, straight home. As long as I'm heading home, that time is still on you until I'm at my home. So if they come and rob me in the night, well, my boss is like, that's not on me. I sent you home, you got home. Whatever happens, if you step out of home or whatever, that's on you. So because they are supposed to look out for your safety and they are responsible for you in that time, they have a duty to compensate you if something should happen to you during that time. It's called occupational safety. So they're supposed to look out for those things.
Yeah.
Now, for example, the law imposes a duty on them to do certain things. Make sure there are toilets, make sure the toilets are clean, there are toilets for ladies, there are toilets for gents. Make sure that if I work at a construction site, the shoes are right, the helmet is right, the gear that I use, probably gloves, are right. If as I'm working, something crushes my finger.
Alan, thank you for I'm sorry for interrupting you. But there's something that has been itching all of us in the office, and I'm hoping that we can have that conversation today. I am on the site. Let's say I'm an engineer, right? And the employer tells me I must bring my own helmet, I must bring my own boots, I must bring my own vest. Generally, I'm bringing everything. Or the way we work here in an office, the employer says I must bring my own laptop. Yet I'm doing the person's work. What do I do in such an instance?
We will get there when we're dealing with these bits. But let's talk about what should be and shouldn't be.
Yes.
One, if I work for you, I give you my time, I give you my skill. Well, you're supposed to give me the field where I can display that skill. If I am good at typing reports, if I'm an accountant, I'm good at using a certain accounting software, give me my tools. The law requires that you give an employee the tools to carry out the work that you've assigned them. That's part of what makes you an employee. If you're hustling, side hustling for that person, what we usually call a contractor, or actually usually it's just the contractors, people like that, or gigists. What I am giving you is the space to work. So come with your tools, do everything, and then give me the final product. But the fact that I am working for you, you're supposed to provide the tools I need. So I shouldn't carry my own helmet. I shouldn't carry my own boots. I shouldn't bring my own laptop or internet to work. Provide the tools. Let me deliver the work. That's what we contracted for.
Okay. So we've agreed that as employees, we are entitled to what is called tools of work. Those tools are supposed to be given to you by your employer. You can't go to a place of work where someone expects you to give them your time, your labor, and your skill, and then you're also, on top of all of that, providing the tools. So we've clarified that issue. Now, let's get into that conversation, and I think we are still getting into the conversation on compensation. Let's say I am a contractor. I'm employed to be a contractor, not these independent contractors. Let's say I do landscaping or any sort of work like that requires like digging, whatnot. And in that process, or actually a better example is I'm a factory employee, right? I deal in assembling, all those things that happen in factories. And over time, because of the constant bending, the person notices their back is starting to hurt them, right? First month, they don't take it seriously. Second month, they actually realize they can't even function anymore because of that backache. And then they notice that backache started only after working at this place. At that point, do I report? Do I tell the employer? Because there could also be a fear. What if they chase the person? What if they chase you for being sick? Now you can no longer help us. What exactly happens when you get an illness because of the work you've been doing?
It's a twofold thing. First things first. Where we begin is that if you realize that the work that you're doing is causing you this kind of problem, you have an entitlement to go to your employer and you say, you see, since I started doing this, I have backache because I'm bending and I'm lifting things that are this heavy. If there's another department, could you take me to that department? I can still do the work. That you can ask for. The law allows you to ask for that sort of thing. But on top of that, they're supposed to also treat you for this injury that you have sustained as a result of the work.
The work, okay.
The worry would be, they'll probably fire me. If they're firing you because of that injury, you have a right to go and say, I think you guys are doing something bad. I'm reporting you for that thing. Which on the side brings up the importance of not being alone. You see, if you're alone in this thing, they can treat you whichever way they want. So that's why most kind of work, what we call employment fields or employees, tend to have what we call unions, labor unions. Teachers have something called UNATO, I believe.
Yes, they do.
Different workers, even the guys who are in the medical fields have their associations that fight for them. Now, if something like this were to happen in my field, I would run and tell them, this place is causing me harm. My back is hurting. So instead of bringing out my one voice, it's very possible. Yes, by sending a representative, all those workers are also coming and speaking, and they're saying, no, this guy, you might need to either switch his department or you'll need to do this and this to make it better, make the working conditions better, treat him. And if he's unable to work going forward, now we get to the conversation of compensation.
Okay. So the general gist of compensation is you are given compensation when you are incapacitated to work. If you get an injury because of your work and you fail to proceed to work because of that injury, you're compensated. Otherwise, you are treated by the employer. In the event that you get an injury, but that injury can be treated and you eventually get back to work, then that injury is covered, or the medical cover is covered by your employer. Now,
just a sec.
Yes, Allah.
Let me ask.
Yes.
You know, when I was growing up, there are things that were not part of our vocabulary. These days, there are bacterial infections, there are UTIs. Is a UTI an infection if I get it at work? And what happens if every time I come to this place and I use the loos, following week I have a UTI, the other week I have a UTI? Is that something I should ask my boss to compensate me for?
That's a very interesting question. Interestingly, if this injury has caused you medical harm and it is a result of the conditions at the workplace, we know very well that there are places where the work washrooms can't even be used by an animal, right? And yet the employer has maintained them like that. You've made complaints, you've done what, nothing is being done. And then you get an injury as a result of that, or you get an infection as a result of that. And you can prove that injury is a result of that. Now that's the problem. Proof, because for medical issues, or for medical compensation, for workers' compensation to work, there has to be proof, a medical report by a medical practitioner that links your job to this injury that you have. So that's how it becomes difficult to prove that the UTI came from this bathroom. They could say that you got a UTI from another bathroom. So that's a bit difficult. But in cases where it's clear that the injury came from this place, let's say you work in a cement packing company and you get a respiratory problem, you can't breathe well, you get asthma or issues like that, and the medical report clearly states that the cause of this is constant inhalation of that cement or whatnot, then you have a claim against your employer for workers' compensation because you are sick, or for medical cover. So for sicknesses that can't exactly be linked directly to your employer, that one may be an issue. But for instances or illnesses where you are working in the factory machine cut off your arm, that's direct immediately. That's direct. Or now there are some that are not as direct, but the law covers them. For example, I was leaving home going to office, and on my way to office I met some border guys. They were riding badly. One of them knocked me. Your employer wasn't there, you are not yet even at work, but because you are heading to work, the law protects you and says that your employer is supposed to cover your medical expenses for that specific injury. So there's a whole act, it's called the Workers' Compensation Act. There's a whole act that talks about different ways, different scenarios, different things that can be covered by your employer when you get injured. But all these are things that we can talk about. I see a lot of you are joining the live. Thank you so much for joining. We're talking about employment, all things work. So if you have questions, please drop them in the comments. I see the producer says we have a question. Yes.
Yeah, so Eddie is laughing and saying, but you people live in the same Uganda as we live.
We're also laughing with you, Eddie.
I think what he touches on something deep is these things are provided for, but
do they actually happen?
Different.
Yeah.
So how does the law help us there?
Okay, so I think I'll just say maybe a word about that, and then Alan will also give his 2 cents. But let me speak to Eddie and to everyone that has since given up on Uganda. I feel like as a lawyer in practice, a lot of the time, people out on the outside feel like the law doesn't work, the law will never catch you until it does. Now, because for us, we are on this side of the law, we've seen instances where the law will actually work because people have, for lack of a better word, deco. Now, the way our system is set up, it's a system of kulemelako. It's not of like you report your thing and then you just go. No, you have to be consistent. You have to follow up the necessary people. You have to provide evidence. You have to make sure everything you're gathering is proper, and the law will definitely help you out. We've handled multiple cases where people are compensated for injuries they've gotten at work. We've handled multiple issues where people get justice from the labor office, even up to the industrial court. So the law does work. You just have to give yourself to the process. Alan.
Okay, to add to that, what Shivan called kulemera ko in law is called being vigilant. The law helps those ones who are willing to be vigilant, to fight for themselves. If you sit home and you say this happened to me and you wait 3-5 years,
TikTok videos.
It's not going to really help you. You're going to make noise, but that's where it will stop. They can ride out that noise. What you're supposed to do is actually what we're helping you now. Know the law. Do not take a year after being fired to come and bring your problems. There is a limited time within which you're supposed to come to court and report. There is a person called a labor officer. A labor officer in Kampala sits at the Ministry of Gender, Labor and Social Development. There is an officer that deals with employment issues. At every district, there is that particular office at the district HQ who will deal with these problems. But if you do not go there, they can't help you. And like Shivan said, if things go bad, you get there, they're tossing you left, right, and center. Well, within 8 weeks, you say things haven't worked. 8 weeks should be about 2 months, I think,
2
give or take. Yeah. So in 2 months, if they haven't solved your problem or they're still tossing you left, right, center, that stuff, move to what is called the industrial court. The industrial court will take your case, will hear your case, and it will not be so formal. If you have a lawyer, take a lawyer. If you don't have a lawyer, just know your rights and what you're entitled to and your facts. Take it there. They will hear you out. There is even a very scary statistic. That's why most employers, when they hear, oh, they've taken me to the industrial court, they will say, come we talk. Because more than 50%, more than 50-60% of the cases that are there are won by the employees. So it's not that these things really happen and employees actually win. It's because many of the employers who are out there who are actually bad rely on the fact that, well, people are scared, you won't report. If you don't report, no one is going to help you.
Thank you, Alan. And I think you've touched something that we're getting into. So I think this is the perfect time to get into it. Eddie and everyone else that's watching us, I hope we pay close attention specifically to this part where we're going to be dealing with the complaints procedure. I have a problem with my employer, or even my employer has a problem with me. Maybe I'm a bad employee. Yes, before we do that, I think there's a question. Yes.
Yeah, I think that's going to lead you into your discussion. Eddie has, I think, gained hope. He says, I'm an agent banker. How do I proceed if the bank reduces commission without notice, since also an employee? Since I'm also an employee, Eddie, could you just re-type that question? I think you missed it. But he says, he's an agent banker and he wants to continue with that case since he's an employee. They reduced commission without
he's informing them. Okay. Let Alan, I think, take it from there, and then we'll come back to the complaints procedure. Yes, Alan.
Okay. I'm not quite sure what relationship you have as an agent banker with the bank. So I'm going to give it to you two ways. If you work as an agent of the bank and the bank pays you a salary that makes you an employee. If it is a commission-based thing, you might not be what we call an employee, but you could be an agent or a contractor for that particular bank. Now, that relationship tends to be slightly different. If you're an employee and they said you work for us for this time and this time, and they changed what they're supposed to pay you, you can go to a labor office and you say, I was supposed to be paid this, and it was changed to this, which is lower. The law does not allow for your salary to be changed downwards. It allows for you to get more salary, not less. If you are an agent, then that is a different conversation you're going to have. You're going to ask why the commissions are being reduced. Just have an honest conversation with them. They tell you why they're reducing. If they're reducing because they think you're not working enough or you're not working well enough, you have a conversation there that you can have. And if they're saying you're not working enough hours, so we're reducing your commission, that means they have put themselves in a position where you're actually an employee and they're supposed to explain why they're reducing your salary without having given you a chance to explain yourself. As a contractor, you do not get exactly the same privileges of reporting to a labor office in case of this. There will be a group, what we call an association of people who work in that kind of business, who can speak on your behalf to this bank and say, why are we getting less commissions yet we're still doing the same amount of work? And then the bank will respond and you come to an understanding with the bank as agent bankers. That's if you're not employees. I think that pretty much covers it.
Okay, thank you, Alan. I think, Eddie, you've gotten a response to that. Let's get into the event. In the event that any of you is listening to us, watching us, and you are an employee or an employer, and you have a dispute with your employer or your employee, say they've not paid you your wages in maybe 4 months. You've written, you're even now contemplating going to your boss's home and camping in front of his gate, and nothing is changing. Or perhaps you have an employee who never delivers on their work. Everything that they have been told to do in their contract, they don't do. They're just really one of those people. And you have a problem that you'd like to resolve. We're going to go through the complaints procedure, or what happens. We're going to take us from the beginning to the end so that we each understand what happens at the different steps. Step number 1. If Alan is my employer and I notice I have a problem with him, maybe let's use the issue of wages because that's usually the most common. My salary has not been paid. The first thing I should do is write a formal letter to my employer and copy your HR in, informing these people. This could be either an email or a formal handwritten letter delivered to the boss. Usually this letter is called a demand or a notice of intention to sue. Essentially what you're saying is, me and you have been in this contract relationship. In the contract, we said that you'll be paying me every month this amount of money. We are now in the 3rd month or the 4th or the 5th month and you've not remitted this amount of money to me. I want you to know that what you could say 2 things. 1, kindly let me know when this amount will be remitted. And if not, or if I receive no response from you, kindly know that I'm proceeding to take legal action. That is what is called a demand notice. It's the first step when you have a conflict. You first inform the person that there's a problem and you'd like to come to a solution. Sometimes if your employer is not problematic, they'll give you a response, they'll explain, and sometimes it ends there. They explain maybe money has not come in or whatnot, but they'll give you an explanation, and if you're satisfied, it could end there. However, if they don't respond or if the response they give you is not satisfactory, you go to step number 2. You take it a notch higher. That notch higher is going to an officer that the law calls a labor officer. What is the labor officer? The labor officer is a person that is given the mandate. The office of the labor officer is given the right to hear and adjudicate over all labor issues in a specific area. Labor officers are at every district. So here in Kampala, we have a labor officer in every district. In Masaka, where there's a labor officer, usually they are stationed at the district headquarters. But in Kampala, we have multiple. We also have one at, I think, KCCA offices, head offices. So if you have a challenge, that's the office then you go to after your demand notice has not been responded to. So how do you get to the labor officer? All you do is walk there. You just walk there and file what is called a complaint. When you get there, they'll give you a form. You fill it and write what your issue is. I am the employee of such and such a person. This is my issue. This is my evidence, etc. Now, when you do that, when you notify the labor officer that you have a challenge with your employment, that labor officer will summon your employer to come and you guys have a discussion. Again, in this instance, the labor officer is sitting as a judge quote unquote, they are not an actual judge, but they are sitting like a judge to decide your matter. Now, the law clearly states that the Labour Office is the first court of instance for labor disputes. So any labor matter first goes to the labor officer before it goes to anyone else, because Alan is later going to tell us about what happens if you're not satisfied at the labor office. But the first people you should go to are the people at the labor office. Now, because of multiple reasons, your issue may not be handled at the labor office. The first week, you have no response. Second week, no response. First month, nothing. Second month, nothing. Now you're wondering, you told me to go to the labor office, they're not helping me. Do I just wait? What do I do?
And at home, people are waiting. They're hungry.
At home, people are hungry. Meanwhile, even your employer now is laughing at you for having gone to the labor office because they're not helping you. What do you do? The beauty of the law, again, as Alan had mentioned, is that it really protects the weaker person. The law has power dynamics. So whoever has the most power, the law tries as much as it can to help this other person who has the least power to come up here, so that there's a bit of equality. Now, how does it do that through this labor office situation? If the labor office fails to handle your complaint or to give you any feedback within 2 months, you have the right to directly go to the industrial court, which is the next court of instance after the labor office. If the labor office, I repeat, has not helped you within 2 months, you go to the industrial court. However, there are times when you go to the labor office and they actually summon, you start the process, they call your employer, you even have a discussion, and you just fail to agree. This one wants their thing, this one also wants their thing, and you fail to come to a middle point. What do? You have the right at that point to make, the labor officer has the right at that point to make what is called a referral, or to refer the matter to the industrial court, telling them, I tried to hear this matter, I've failed, these guys have failed to reconcile, I'm sending them to you to deal with it. So that's how matters come from the labor office to the industrial court. It can be by referral or by your own initiative if the labor office is failing to help you after you've filed the complaint 2 months. Alan, we have reached the labor office, we've tried mediating, we've tried talking, or even the labor office has given a decision, and one of us or both of us are not satisfied with that decision. How do we proceed?
Okay. Once the labor office has made their decision, you're probably wrong for having fired this person, or you are wrong for having demanded that they work 16 hours in a day and rest for only the balance of the hours. And for you're unhappy about it, you do what in law we call appeal. Because the next court that comes after the labor office is called the industrial court. Now, this court was specifically set up to handle matters related to employment. So if you're not happy with what came out, then you ask for that ruling of the labor office and you take it to the industrial court and you file what we call an appeal. There are documents you'll file. I don't want to get into the intricacies of those, but you will make an appeal to the industrial court. The industrial court will only listen to your appeal about a matter of law. Probably you're saying things such as, they were wrong to say that I couldn't make my employees work 16 hours, or they were wrong to decide that I hadn't gotten leave and so I shouldn't be paid that leave, yet I had worked for this period and had never gone for leave. If you also have facts are the things that actually happened. If you do have facts that you think you still disagree on, you ask that court, the industrial court, to hear those facts again. It's not automatic. They're supposed to actually go and be like, okay, you have some facts that were not settled at the other level that you think there's a problem with. Ask if you get their permission, their leave, we call it leave, then you bring up arguments about those facts. But they primarily want to deal with matters related to the law. What does the law say about your relationship and your dispute between yourself and your employer or your employee?
Okay.
So you get there, you will argue your side, they'll argue their side, and if everything goes well, a decision will come out. The decision may uphold the decision that was made by the labor office, or may change it or wipe it away altogether and make a fresh decision. If you're satisfied with this decision, they will give you a time frame, like beginning today up to this time, make sure you pay your employee what you owe them. If you do not pay it within this time, every other month that goes by, there is a certain interest they will put on that amount you're supposed to pay, and you end up paying it.
Yeah, okay.
If you are still unhappy, obviously,
Yeah.
because some people are just never satisfied. If you're still unhappy about all this, then we are going to leave the industrial court and we're going to come back to the formal courts that you all know about.
Yeah.
So you're going to find yourself going to the Court of Appeal. Court of Appeal will hear the matters of law and be like, so you're saying that they were wrong in law to make this decision, and you're supposed to give your explanation as to why. It's a much more strict court. If that should then fail, well, this time you're going to need to beg a lot to go to the Supreme Court, because not everybody goes there. They just can't entertain every case just
Everyone.
because for me I'm unhappy. You must actually give them a reason why you want to go see them, and then you can take your case there.
Okay. So, just a very quick recap for everyone that's watching us. If you have a dispute with your employer, what are you supposed to do? Point number 1, you go write a demand notice informing your employer that you have a problem with them and you need that problem fixed, or you'll take legal action. Point number 2, if your employer does not help you in point number 1, you then go to the labor office in point number 2 and report to the labor office, file your complaint stating what your issue is against your employer. Again, it could be maybe benefits that you're not being paid. It could be different labor disputes. It could be that you were wrongfully terminated from your place of work. It could be, again, so many different things. So after the labor office has given a decision, you may not be happy with the outcome of that decision. Because of that, you then have to go to the industrial court. The labor office will refer your matter to the industrial court to hear it. After the industrial court, if you're still not satisfied with that decision, you have the right to appeal to the Court of Appeal for them to hear the matter again on facts, on points of law and fact, and see whether it should be changed, it should be removed, it should be maintained. The Court of Appeal will decide. And in extremely rare cases, you have the alternative to also get up to the Supreme Court, where the matter will finally be decided. If you are still not happy with the decision at the Supreme Court, we shall send you prayers. Yeah. I see we have a question. Yes, please.
I have many questions.
Okay.
Oka says, can I take paternity leave in installments and not at once?
Okay. Alan, can your fellow men take paternity leave at once, or today I can go, tomorrow I go back to office? Today I'm at home, tomorrow I go back to office. How do you take paternity leave?
Fellow men, don't hide at the office. Paternity leave is different from maternity leave. So let me explain. With paternity leave, you're supposed to take it once, because they believe that those first 7 days are very crucial. Your partner needs help. You need to bond with your child. So go and bond. You will not bond in pieces, mpola. So you take your paternity leave as one lump sum, go enjoy yourself and your partner and your child, and then come back to work when you're settled. Because if you keep coming, they'll be like, hey, the milk is done. The porridge is done. Kara has chucked. What? Now you're here at work, and then you're thinking of running to the shops to buy more light. Because these days it's called light. You have to go back, buy light. On top of that, then they're saying that the pampers got full, the size was wrong, then you're getting a border. You see, so go, have your paternity leave, finish it, and then return.
Okay.
And the weather has disagreed with us. Anyway.
Yeah.
Maternity leave, on the other hand, is where you might draw a small distinction.
Okay.
The law will allow you to chop it into two. You can start your maternity leave before you're due to give birth. But a minimum of, I believe, 4 weeks must be after you've given birth. So you cannot just go enjoy your maternity leave, then give birth, then come
back the day
necessarily
after.
appear and return to office. No,
Yeah.
there's a period you must spend at home, mandatory. Yeah.
Okay, thank you, Alan. However, would like to also let you know that employment issues are contractual issues. That means, whereas the law states certain things, you and your employer may decide something else. We've seen HR manuals where they state that, let's say, paternity leave is 20 days, and they give you a lot of time, and within that time they tell you you can take it in bits, in pieces. Now, based on your contract with your employer, these days can be allocated as you have agreed with your employer. But generally speaking, in the law, you take paternity leave as a lump sum. However, the law, as we mentioned, is just a starting point. As Alan had said earlier, the law is not, we don't go below what it has said, but we can go above it. The law could say, for example, that maternity leave is 2 months, but for you at your office, they give 3 months, or they give 4 months of maternity leave. Now you won't start telling your employer, no, the law says we only get 2 months. Me, I want 2 months. Yet they are telling you you can get 4 months off. So again, employment issues are also heavily contractual in nature, which means if there is a meeting of minds between your employer and yourself, it is okay. You guys can run things as you have agreed under your contract. However, these things must be written down either in your contract or in your HR policy.
Let me
Yes.
jump somewhere else
Yes,
before you
Alan.
go. You had mentioned, actually, I think you hinted on it. I'm disturbing my employer. Where does my employer run to? I'm being a problem. They tell me, show up at 8, leave
Me,
at
I come
5
at
p.m.
10.
And I want to show up at 5 p.m. at 10 a.m. By a certain 3 p.m. Me, I'm like, I've checked out me. My brain has saturated ngenze. Stuff like that. Where do employers run to when they need to deal with an employee who has refused to obey or who's a problem at work?
Okay, now this is where the Employment Act also gets very interesting. There are two kinds of things under the Employment Act. The first one is termination, right? Termination is they've ended the contract. It could be for various reasons. They no longer have money at the job to pay you, or the contract has ended, the time has reached, or different things. That's under termination. But there's also something called summary dismissal. Summary dismissal is what do I call it? A whip that's given to your employer to use when the employee becomes a problem.
A big problem.
You won't come and become a headache for someone in their establishment and then they'll have to keep you and just keep quiet. No, the law is fair. So in instances where the employee has become a problem, there's something called gross misconduct. Gross misconduct essentially is something that is defined under the HR manual of the place where you work as something that's so bad that they can't keep you. Again, there's no one definition, but according to different places of employment, that could mean anything. So, for example, at your place of employment, gross misconduct could mean failing to turn up on time. People say you're supposed to be there at 9. For you, for 2 months consecutively, you're there at midday or even 2. So in that instance, the employer has the right to summarily dismiss you. What summary dismissal means is that they do not have to notify you, as we earlier said, that you are going to be dismissed. Kagwira there, and then they just tell you pack your belongings and leave. We will not take your things anymore. So they do what? They fire you there and then. That's what summary dismissal is. So a lot of employers use summary dismissal as a remedy to employees that have become a problem for them, toxic to the work environment. However, the fairness in this is that if you feel as an employee that you have been unfairly dismissed or terminated, you still have the right to report or file a complaint with the Labour Office and consequentially the Industrial Court if you feel like there's a problem and you can prove what that problem is. Yes.
So let me just add to this. There is usually a thing where you say, oh, what happens if I really want to keep my job? I have a problem with my boss, but I really want to keep my job. It either pays well or at least it pays my bills, and I still want to keep this job. The reason the labor office exists is to help you navigate these things. Mpola, mpola. They can even do it confidentially. They simply say, we've received complaints that people here are being made to work 10 to 12 hours a day, as opposed to the 8 hours. Or you're not paying them on time, you're not paying their NSSF, you're not paying their pay as you earn, stuff like that. You can still go to the industrial office, to the labor office, and they will chip in and call your employer and discuss these things. There will not be a demand to say, who reported us? Shivan. Hey. And that's a problem. They can actually say you unfairly dismissed them, and then you'll find yourself paying fines and compensations that you can't handle.
Okay. Thank you, Alan. I see that there's a question in the chat. Someone has asked, is it legal for employers to deduct salaries? We were supposed to talk about salary deductions because there are two kinds of deductions. There are deductions that are statutory, and then there are deductions that are not, that just come as a result of the employer deducting your salary for whatever reason. So maybe I'll just quickly hint on the mandatory deductions, and then you could tell us if the employer wakes up and says, I'm overpaying you people, let me reduce by 10,000, or the economy is not doing very well, let me reduce by 200,000. What do I do in that instance? So first, the Employment Act clearly states that deductions that are statutory. One of those is, all of them are, okay, no, they're not all taxes, but one of them is pay as you earn. Pay as you earn is a tax, basically, that we pay to the government for earning money in Uganda. It hurts all of us, it makes us cry, but we pay it because we're good citizens. So your employer must be remitting pay as you earn. If they are not, URA is probably going to come and close you guys down. So that's something that should also be covered under your contract of employment. Has the live ended? Okay. The other thing is, all right, we are still here. The other thing is NSSF. Your NSSF remittance is also a mandatory remittance under employment law. Let me say it as I look at you directly. If you have a contract of employment and your employer is not paying your NSSF, that is a crime. It is illegal. You can report to NSSF and they will come for your employer. It doesn't have to be spread all over the news. We put you on TikTok, what. It can be a confidential approach. You tell them, or you file a complaint and tell them, please keep this confidential, but our employer is not giving us NSSF. Why? Because this is social security. After you've worked, there should be something to show for it. So that's what NSSF ideally is. Now, those are the two mandatory or statutory payment deductions. Anything outside that, Alan is going to speak about. Yes, Alan?
One more. Every year you pay something.
Yes, LST.
LST. That's also statutory. And to just make it clear, when we say taxes, it's not your employer who is paying taxes. It's you who is paying taxes. The only job your employer is doing
is being the middleman.
He's the wheelbarrow that carries your taxes
to URA.
So, if they are not paying your taxes, they are stealing money from you. If they are not paying your NSSF, by the way, your employer pays NSSF, but you pay NSSF. So you pay 5% and then they'll pay 10%. So which comes to about 15% of your salary. So they are not only not paying their 10%, but they are eating your 5%, which you could be taking to the bank, going to watch a movie. So it's not that they are paying, they're eating your money. Let's talk about the other deductions. The other deductions that the law would probably allow are things you agree to between yourself and your employer. For example, you have a circle at work You say every month, take 200,000 off my salary, put it in the circle. So when your salary comes, it's 200,000 less by pay as you earn, less by NSSF. You don't go crying and you say, they ate my money. If you get a salary loan, same thing. You tell the bank, you'll chop it from my salary. And you also notify your employer. If your employer pays your salary into the account, and on the account it's less the amount you're supposed to pay for your salary loan, it's not an illegal deduction because you said yes to it. So as long as you have said yes to it, it's not illegal. What is illegal even if you say yes to? If your employer says, wano tugenda tandika okwambala uniform, and then you, Shivan, or a one Chidi, has to pay for the uniform that they're going to wear at work. Even if you say yes because you're scared of losing the job, it's an illegal deduction. You might keep quiet today, but you can always go and say, Badia sente zange, I am entitled to my money. Meals are not supposed to be taken from your salary. If your boss says,
so repeat it. Let's repeat it for us.
Lunch. Your boss is supposed to give you lunch hour. Your boss is not supposed to give you lunch. Some bosses are nice. They will give you lunch. But if your boss gives you lunch and says, now, the lunch you ate yesterday was 10K, was 20K, I want it from your salary, that boss is wrong. Give me my lunch hour, I'll go look for Chukomando, but don't touch my money. That is the law. Anything that touches your salary, even if they're saying it's a benefit that is not either by law or you've been forced to agree to or you have not agreed to, is illegal. Period.
And he says you should talk about forced insurance on employees, so I think you touched that.
Insurance. Bwemba sagala. Do not take my money and put it into insurance. What if I have a witch doctor who knows how to look after me? What if I'm very prayerful? Leave my money alone.
Yes. Thank you so much for mentioning that also, because we've also had a lot of concerns on that. In our family, we don't fall sick. But when on Sibioko, you want me to take your insurance. I don't want your things. So yeah, I think we've clarified that deductions that are eventually taken off your salary that are not statutory deductions can only be taken off your salary if you have agreed to it. If it is not agreed, if you've not consented, it's a point of a complaint and you can bring this up to the labor officer and they'll be able to support you in this. Now, Alan, we have a few more questions. Someone asked, after we've appealed to the industrial court, do we actually go to the Court of Appeal or High Court? How come we don't go to High Court? How come we go to Court of Appeal? Someone is asking. Explain the law to us.
Okay. The Court of Appeal is higher than the High Court. We agree on that, right?
Yes.
Now, the judges that sit at the industrial court, they may be less formal because they're dealing with a whole range of employees. It does not make them any less of a judge than the judge who sits at the High Court. So the High Court and the industrial court are at the same level. So you either go to the High Court. In certain instances, some people will just actually dodge the industrial court, but you'll give reasons why you're running to the High Court when you could have gone to the industrial court. But those two courts are at the same level. So you cannot come from a court here and go to another court at the same level to say, mommy has refused to give me juice and you're reporting to daddy in the same home. You go to the LC and report. So that's why when you leave industrial court, you go to a court that's higher. Appeals go to a higher court as a matter of law. They don't go to courts at the same level.
Okay. Thank you for explaining that point of law, Alan. And thank you so much for asking questions. We see they are coming in. We are excited to answer each and every one of them. I think there's someone who is saying, what about if there's a shortage at the restaurant and they deduct all our salaries? Again, I think we covered that. If a deduction has not been consented to by you, then there's a problem. And then someone has said, what if it's a contractor contract? I think that's something I'd like to touch on. Now, the contracts we're talking about today are contracts of employment or contracts of service. What that essentially does is it makes you an employee that has a relationship with your employer, and that relationship gives you certain benefits, certain rights, and certain responsibilities. Now, if the contract you have is a contract, an independent contractor's contract, that is not a contract of employment. You're not a person's employee when you have an independent contract. For example, a house is being built, right? And you've been contracted, they've given you a contract to supply bricks or cement or whatever to that place. That doesn't mean you're the employee of the person who has given you the contract. No, you're a contractor. Now, if there's an issue that arises from that contract, either you've not been paid or many issues that arise because of contracts, that issue does not go to the labor office, neither does it go to the industrial court. Those courts are a preserve of people that have contracts of service. Now, the people who have people who have contracts that are not employment contracts, the court you go to when you have a dispute is either the magistrate's court, the high court, court of appeal, Supreme Court. Why? We start from the magistrate's court because these are ordinary contracts. They look at them as normal contracts, like a contract I can have with Alan for Alan to supply me with something, or a contract I can have with Trudy for Trudy to buy something from me. Now, those ones are, you go to a court based off of the amount of the contract. So, for example, you said you are going to supply 10 million worth of bricks. You supplied your bricks, they didn't pay you, or they didn't pay you in time. That goes to the magistrate's court. Why? Because the magistrate's court has a cap of 50 million. So any matter that is below 50 million can go to the magistrate's courts. However, let's say you are contracted to build a house. You're an architect. They said, oh, you should come and build a house, or an engineer. And they failed to pay you, and the money was 100 million. You go to the high court. Why? Because the high court has a cap of anything above 50 million. So if you have a contract and your contract has been breached, and your contract is not a contract of service, it's not an employment contract, then you utilize the other formal court systems. You go to the magistrate's court. If the matter refuses, or the high court, if it refuses, then you appeal to the court of appeal or to the high court, depending on the court you're in. So that's for that. Alan, someone was asking, unless you have something to add.
No,
yes.
just making one thing clear on this.
Yes.
The reason why, like Shivan has said, you're supposed to go to these ordinary courts is because what you're demanding for is the amount that you should have received. You're not demanding for salary, you're demanding for the amount that made you enter that contract, the contractual amount. That's why you're supposed to take it to any of these other courts.
Okay. Yeah. Thank you, Alan, for that clarification. Someone asked, can the employer force you to join the circle? Hey, guys, it's tough out there. And that people have made your lives difficult. No, an employer cannot force you to join a circle. If you don't, what if me in my life, I don't want to spend? I just want to I don't want to save. I just want to make my money and eat it. Everything that the employer gives me, I just want to eat it. Apart from NSSF, the rest is for spending, chop money. So an employer cannot force you to join a circle. However, if you willingly decide to join the circle, and the circle has certain rules and regulations, you must adhere to them because you willingly decided to join that circle. Alan, someone here is asking, what if an employee causes damages at work? What do we do? Do we remove from their salary? Do we chase them? Do we report them to police? What happens if someone comes here today? They decide that our windows should be their target practice. They break our windows, they break the television. What do we do? What does the employer do in that instance?
Okay, so there's something we talked about. You can only put extra things in a contract that are advantageous to an employee, not disadvantageous. There are very many people who they get an employment contract and they add in things like any damage we suffer here as a result of your negligence or whatever, you're going to pay. Yeah. That is wrong. That's actually illegal. So you might actually deduct my money now and then fire me, and then I'll come back for my money.
Yeah.
Because the law does not allow you to charge me for damages at work if I'm not good enough, because you did not hire me to make sure there are no damages. You hired me for my skill and for my time. If I'm not good enough to fulfill what you hired me for, I'm causing you losses and whatnot, get rid of me. Bring somebody who will make sure there are no losses. That's the law. Do not start taking the money from me. Now that becomes a point of slavery, which the law does not allow in Uganda and in employment. So if they're deducting your money because they say, oh, there was a short, there was a what, that is wrong. You bring this to the notice of the labor office, which will confidentially come and talk to your employer and say, we hear that you do this sort of thing here and there. I think this is wrong. Remit the money. If you think there's a problem, go deal with your employee according to the internal procedures, which are disciplinary actions, which the law will allow to a certain level, which takes us to the point why it is wrong to simply say there was a loss, you're paying for it. Was there a fair hearing? And what was the result of that hearing? And if there was a hearing and the results came out, there are set things that can be done. You can say, we suspended this person, they were on half pay, so we will not give them the other half pay in the period they were suspended. However, you don't say because they did this, we came out, they were guilty, so we're taking their money. Illegal deduction again. So in the time you find that they did something that you disagree with, deal with them according to the law. Either fire them, suspend them, or warn them, but don't take their money for anything.
Okay. Thank you, Alan. We are still getting into your questions. Thank you so much for engaging. Thank you for asking. We're having a conversation on all things employment and work. We're soon wrapping up, but we just have a few questions to go, and that's what we're going to get into. Someone has asked, what happens when staff contracted to do a job for only 6 months work for almost 2 years consistently? Now, in the law of contracts, time is a very essential element. What that means is contracts are time bound. They are not eternal. Like there's no contract that says forever and ever and ever, amen, we shall always be together. No, contracts must have a time period within which they should be accomplished. Now, if you contracted for 6 months, you are contracted for 6 months, and now the contract of employment has gone on for 2 years. Consistently, meanwhile, you're still working the way you are working. The law will make two assumptions. One, that the contract has been extended. If you're, let's say the contract is supposed to end in December. December reaches, there's no communication on that, the fact that your contract has ended. In fact, they're even still sending you work emails. They are sending you more work. They are saying what? They have extended. Every action shows that they've extended the contract. Then the law will look at it like that contract has been extended. So if the contract is extended, therefore the benefits that accrue under that contract also extend. Meaning, in the extra 1 year and 4 months that you've been working as the contract is extended, you must receive the benefits of the original contract because there was no termination of that contract. Someone asked Alan, what if I am working for a place that causes me stress? The person has even gotten high blood pressure because of this place. Can they get compensated for that? The place is toxic. Every time the boss enters, their heart is pumping, they collapse. Can you get compensation for getting high blood pressure because of a stressful work environment?
Okay, so I'm going to answer the question, but I'm going to pull us back a little bit. Shivan said something very important. No employment is permanent. Of course, you could get a job and they say permanent and pension. Tekitegeeza nti n'omuzimu gwo, it will keep working there.
No.
At a certain age, you will stop working. There is an end to all employment. So, how does employment end? One, death. Either me, the employee,
Or
I get
you.
to a point, or my employer, if it's an individual, has gone out of the life of this world. The employment comes to an end. If they're unable to pay completely, if I have been sick for a certain period of time, they can end that employment. If they become broke, what we call bankrupt, employment can also end. Or if the term that we agreed to, 6 months, has elapsed. Now, the question you asked again.
Yes, high blood pressure from a
It's
stressful
high
work
blood pressure.
environment.
The reason I left that to the end is because it's a bit new in law. It's a new creature of law.
Yeah.
There is something we call constructive termination. If I am to actually loosely put it, I call it a toxic work environment. Your employer is supposed to make sure that you're not the most cheerful worker, but it must be so conducive as to let you do your job. You work here, but now that you're here, every time you get in, the place is smelly. You're probably getting sick from this, that. It's not a conducive work environment. Or the moment you get in, there's blaring, there's music that's blazing and whatever. You're like, my God, I can't focus. I have a headache. There's a guy doing this and this. There's someone insulting me. All these things make a toxic work environment. If you leave a workplace because it is toxic or because it is so bad that you probably now have a heart condition, you have stress, you have depression, it's going to be taken that your boss fired you wrongly. Why? Because he has put in place such a situation that you just can't endure.
walk
You have
there.
to go.
Yeah.
Constructive termination or dismissal.
Okay. Thank you, Alan. Thank you so much, everyone that's watched us today. We have enjoyed having this conversation with you, and we are going to continue having different conversations on different topics on the law moving forward on TikTok Live. Barefoot Law, we continue to remind you, is an organization, an NGO that offers free legal information and guidance services to you, all our people. We encourage you to follow us, share the link to our page, and just spread the news that we are giving free information. If you have a legal matter that has not been handled today, you can reach us to speak to a lawyer directly. You can call us on 0800 0022 0000. The numbers are going to be put in the chat, or you can call us on 0392 177 405. You can use those numbers to speak to one of our lawyers on any legal concern that you may have, and we shall be able to serve you. Alternatively, pardon?
There's a question.
Okay, there's a question. We have, I think, about 3 minutes. There's a question for Alan, and the question is... Well, the question is by Alan. What do I do if I get a permanent injury due to work which restricts my physical abilities? Okay, so Alan had initially mentioned that you get what is called workers' compensation under the Workers' Compensation Act. What that means is you have to prove, you get a medical report. Immediately you get the injury, you file a complaint to the labor office and notify your boss. They'll get a medical practitioner to review you and see what the injury is and the extent of it, and you'll get compensated for that injury, either monthly installments or a lump sum of money for both the medical but also for the time that you would have worked had you not gotten that permanent injury. And Alan is going to also give us his parting shots as well as an answer to that question. This is my parting shot. 1, make sure you have an employment contract. Make sure you've read it and understood it, and you have every benefit clarified under it. Make sure if you have an issue, you don't just sit on it. You actually reach out to the people that will be able to help you. Thank you for watching and have a lovely afternoon. Alan.
Karen, tumira, abeo. Just kidding. Seriously though. The thing that we mentioned about compensation. What the time that they're supposed to give you is 60 months. I think when you calculate 60 months, it comes to 5 years. So Just like you said, if it is total incapacity, total 100, that's 100% times the 60 months times your salary, and then you'll get an amount. That's estimated to what you'll probably get. But as a parting shot, don't sit on your rights. We sit on our rights a lot of the time and nothing gets done, and we think the law doesn't work. So do your best. If there's a problem, hurry. Don't wait a year. Don't wait 6 months. Don't wait how long. When it happens, run to the labor office, seek for advice on how to solve your problem, and they're going to help you. Yeah.
Okay, so from all of us here at Barefoot Law, have a lovely, lovely afternoon. We're going to see you in the next live. Make sure you're locked on our page, waiting to see when that is going to drop. But in the meantime, you can engage with all the videos on our page. We also have a highlight app that has work. So everything to do with work and employment, we have our videos up there and you can watch and get information. Bye.
Before we get a workman's compensation, or what's the thing called? We don't give you lunch.
Oh, yeah. The thing about lunch.
Have you ended?
The thing about lunch. Now, it's that they give you a lunch hour, but they are not supposed to give you lunch. So you can give me the lunch hour, but you're not supposed to touch my money to buy me lunch. I can find my own lunch. Yeah.
Hey. So even if they have a restaurant?
No, and the law actually is very strict about that. They're not supposed to force you to use a restaurant that they own to give you lunch.